So today we're going to go ahead and take a look at selective incorporation and the doctrine of selective incorporation and what that means. But I want to draw our attention to pretty much the thing that sort of launches this class, the civil rights and liberties class, at least through the lens of the courts, and that's this footnote that occurs in Caroline Products in footnote 4. It's so famous that we simply just refer to it as footnote 4 because, well, that's all it needs to be known by. Footnote 4 was a signal from the court saying that the court was going to move away from considering issues of a sort of economic scale and turn to more individual level rights. And if you read this second quotation that's up on the screen, it'll make it clear what the Supreme Court was signaling it was doing. It says it is unnecessary to consider now whether legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation is to be subjected to more exacting judicial scrutiny under the general prohibitions of the 14th Amendment than are other types of legislations, nor do we inquire whether similar considerations enter the review of statutes directed at particular religious or national or racial minorities, whether prejudice against discrete and insular minorities may be a special condition, which tends seriously to curtail the operation of those political processes ordinary to be relied upon to protect minorities and which may call for a correspondingly more searching judicial inquiry. In essence, the court said in footnote 4 that it was going to change at least parts of the cases it heard to look more exactingly at cases which discriminated against, as you can see, religious, national, racial minorities. Anyone that was discrete and insular was now going to receive increased scrutiny by the United States Supreme Court. You'll notice that most of the cases that we do come after Caroline Products, come after the publication of footnote 4, and that's not a mistake. Many of the cases that deal with these sorts of protections only occur after this moment in time. And so the Supreme Court said it was going to step into this area. And so it's important to know that footnote 4 in Caroline Products happens after a long period, a long divisive period of the Supreme Court making very activist decisions in an economic bent. And there was a significant amount of negative fallout because of that, which sort of impugned the legitimacy of the court to some extent. So the signal was that, hey, we're going to back away from that area, but we're not backing away. We're not stopping. We're going to continue to weigh on issues of national importance. However, those issues of national importance are going to deal much more primarily with individual level rights and group-based rights. So the reason why this class can exist is because the court signaled that it was going to steer away from the jurisprudence of which it had had for almost 200 years into a new, more substantive area dealing with these sorts of discrete and insular minorities, which is how they put it. So let's talk about the process of nationalization and the incorporation of rights. Let me pull up my notes. There we go. So to understand what nationalization and incorporation is, you have to really look at the Bill of Rights particularly. And primarily the one that we're going to focus on, at least right here in the beginning, is the First Amendment to the Bill of Rights. The Bill of Rights initially applied only to the federal government. And despite what Madison said when drafting the Constitution, that he wanted to include restrictions upon the states, that the Bill of Rights might apply to the states, that never makes it into the final draft. So the final draft of the Bill of Rights and the final draft of the Constitution really doesn't include restrictions upon the state. It actually includes numerous gifts to the state, back in the 9th and 10th Amendment, which gives rights to the states respectively. The 14th Amendment, however, in large part changes this. And the 14th Amendment was passed during a time what we refer to as the Civil War amendments. It's the 13th, 14th, and 15th Amendment. Well, the 14th Amendment contains a clause, the Equal Protection Clause, that many individuals read as being a restriction upon the states. And it is through this restriction upon the states, through this 14th Amendment, that ultimately we begin incorporating parts of the Bill of Rights to be applicable to the states through this Equal Protection Clause. The process by which the court ultimately does that is what is known as selective incorporation. Selective incorporation was the piecemeal, over time, incorporation of particular parts of the Bill of Rights to be applicable upon the states. Now, this selective incorporation, when I say piecemeal, I truly mean piecemeal. It's not as though one case occurred and then they're like, all right, the totality of the First Amendment is now incorporated upon the states. They incorporated small parts of amendments to the states. They didn't include amendments in their totality. And it was over time that these very small parts began to build up. And we're to the point now where if you were to look at the Bill of Rights, we've almost reached total incorporation of the Bill of Rights. Remember back to the first day of class, I discussed how the Third Amendment of the Bill of Rights is still not incorporated to the states. But almost the entirety of the rest of the document is now made applicable upon the states. The process by which they engaged in this was exceedingly slow-paced and deliberate. The court attempted to build up its legitimacy and the Constitution's legitimacy by not going through the process of what will be referred to as full incorporation. And it only included rights which it thought to be fundamental in nature. And we'll get a real idea of what fundamental in nature is when we begin dealing with the cases that populate this area. The last amendment that was incorporated upon the states was done so in 2010. So this isn't just history. It's occurred in your lifetime. And the last amendment that was incorporated upon the states in 2010 was the Second Amendment. So the Second Amendment was the last one to be selectively incorporated to the states. So what that means is up until 2010, states could and actively did restrict firearms within their states. So this incorporation process is ongoing and definitely needs consideration from us to understand how the United States Supreme Court extended its jurisdiction over lots of particularized areas in which it never had jurisdiction before. Sort of like when the court in Marbury versus Madison gave itself the authority of judicial review, this selective incorporation process now put the states under the purview of the federal government, specifically the U.S. Supreme Court, in particularized areas contained within the Bill of Rights. Largely, where we are now, this process of incorporation has turned out to be non-ideological, at least looking at Supreme Court justices, that the idea of incorporating these rights and protections upon the states turned out to not be an ideological issue. It isn't though liberals or conservatives were more likely to incorporate rights than the other. Across the ideological spectrum, these rights were made applicable upon the states. And so it was one of those rare areas where we see the Supreme Court acting as a uniform, united body to incorporate these rights to the states. There may be differences in terms of who would win said case, at least on the merits, but almost universally the justices agreed that a particularized right in question should be incorporated applicable to the states.